All right, good morning. Welcome to this talk on Without Prejudice. It's Scope and Limits. It's a talk I've really enjoyed putting together, and I hope you enjoy it almost as much as I did. The talk is being recorded, and it's going to be sent out along with the slides, which hopefully you've all had received this morning. And it's going to be also posted on the website in recorded form if you want to catch up and see it again. This is likely to be the last of the King's Young Professionals talks that I do. Partially because my claim to being a young professional is growing slowly more ironic as the years wind on. And it's one, as I say, I've really enjoyed. It's certainly been my experience that the talks that I've been able to put together and the talks that I've engaged with that I've found that have been most useful have been those where we're dealing with a doctrine that we all had encountered, we all sort of know about, and yet we've perhaps never had a chance to explore the boundaries of. And Without Prejudice is exactly in that sort of category of a doctrine that we've all encountered, we deal with from our very first days in practice, and yet we oftentimes find ourselves then in positions of difficulty or conflict when we hit up against the boundary of that doctrine and when it applies. I want to talk about three things, the first of which will likely be very intuitive, which is the content of that doctrine. That'll probably be very familiar to most of you. Secondly, when the protection applies, that is to say, the boundaries around the Without Prejudice doctrine. And finally, the circumstances under which the protection is lost and when the court will look behind it. Some of those are very straightforward. Others are far more interesting. All right. So what is the doctrine itself? Most of us probably already have a good idea of what we're dealing with. The Without Prejudice rule governs the admissibility of evidence when we have negotiations that are genuinely aimed at settlement, whether oral or in writing, which cannot be produced before the court in evidence. And as I say, that's probably intuitive to most of us. There's a lot of commentary within the authorities about where this doctrine comes from, and unsurprisingly, one of the main justifications that the courts have routinely used is in relation to the public policy benefit. If parties are able to put their cards on the table, say where they're at, and not have to be worried about a damning admission that may come back to haunt them, they're more likely to set it. And that's intuitive enough. There's a second rationale that undergirded at least some of the earlier cases, which we don't see quite so much popping up within the case law. And that's a rule based on the idea of some sort of implied agreement between the parties. So if A and B are in a dispute, they're heading their documents without prejudice, might it be that the court says, well, we can imply an agreement on the part of A and B not to reveal contents of these negotiations in evidence? As I say, it's more the public policy rationale that the court will look to when it's trying to work out in a boundary case where the rule does and does not apply. And again, I've just put in here, especially the classic formulation in Cuts and Head, the public policy rationale based upon encouraging negotiation. If it is said that, as Lord Bingham once said, that the law loves compromise, then there is an obvious rationale in terms of trying to promote that compromise by giving parties an incentive to disclose information that they may be worried would otherwise be used against them, in order to get round the table and get something agreed. Another general principle that I think underlies both the scope of the doctrine as well as the boundary cases is that the courts are generally erring on the side of upholding the protection. And that does make sense. If you're constantly looking over your shoulder thinking, well, is this going to be caught by an exception? Is this really going to fall within the boundaries of Without Prejudice? You're less likely to have that free exchange of ideas, admissions, etc., when you are negotiating. And as a result, what's often been called the umbrella of the Without Prejudice rule is not something that the courts will lightly say you've stepped out from underneath, unless there's a compelling doctrinaire rationale for them to do so. So when does the privilege apply? Well, there has to be, in orthodox cases, you would say there has to be a dispute that has arisen. And that dispute doesn't necessarily have to be in the context of a litigation that is imminent or that has already arisen, but it has to be the sort of thing that is a possibility if negotiations break down. There is authority to say it's not good enough that you're merely sort of reciprocally disagreeing with each other. There has to be some sort of reasonably coet dispute that where litigation might be a result if there's no agreement. That's the orthodox rationale. There is some mention that there could be instances, though I've never seen this arise in practice, where the court says, well, there isn't actually a dispute that's arisen, but both parties have been heading their documents without prejudice. And Lord Justice Lewison in Avonwick seems to think that that minor rationale, that other rationale of implied contract or implied agreement, might hold to protect those documents from being submitted in evidence on the grounds that even though they work within the orthodox use of without prejudice, that's actually what both parties intended anyway. And finally, a very brief note, as I'm sure most of you are already aware, without prejudice is not merely shorthand for without prejudice save as to costs. There is a difference between the two. To mark documents, and we'll deal with marking of documents in a moment, to mark them without prejudice is without something more to say that they may be excluded even on the question of costs. To say without prejudice save as to costs obviously preserves your right to refer that document on the issue of costs. The Vestergaard decision does make clear, though, that whatever the label, if you say without prejudice, but otherwise in the document make clear that you intend to refer to it on the issue of costs, that may save you. Best just to use in the header, whatever it is that you intend for the scope of the doctrine that you're trying to apply. That brings me on to more general discussion of heading documents without prejudice, or otherwise declaring correspondence or discussions to be without prejudice. And there's two equal and opposite errors I think that junior practitioners can fall into in regard to this. The first is to believe that if it's headed without prejudice, and if it's not heading without prejudice, that is determinative of the question as to whether or not the privilege applies. And that's not right. There are many times that you will see correspondence, especially from litigants in person or perhaps legal advisors who could be better advised themselves, that has no content that is aimed at negotiation, but it's simply headed without prejudice, without any further justification or rationale. So we do see that sometimes. But there's a second error, which is to say that actually it doesn't matter at all, therefore. It is true, of course, that there may be cases, and there will be cases, where the court says, because these were submissions, these were negotiations that were aimed at a negotiated settlement, they attract without prejudice protection. Fair enough, even if they haven't been labelled as such. But that doesn't mean, as the Rusham-Tompkins case makes clear, that there is no benefit to labelling your correspondence without prejudice to make clear beyond doubt what your intentions are. That's not going to transform correspondence which is clearly not without prejudice into without prejudice, nor is it going nor is the converse true. It doesn't change what's clearly one thing into another. But where it does make a difference is in borderline cases. And I've put the Bradford and Bingley and Rashid case, which we'll look at in just a second, down as just an example of that. And where you have borderline cases where the courts will look at it and say, it looks a little bit like a without prejudice case. It looks a little bit like without prejudice correspondence. When you see that, the likelihood is that the courts will take into account the question of whether or not the documents are headed without prejudice when they're determining their character. The Bradford and Bingley and Rashid case is an excellent example of I think one of the hardest cases that arises in dealing with the boundaries of the prejudice of without prejudice. The reason for that is this. One of the cases that is difficult is where you're dealing with mere statements, mere concessions, or mere admissions, but the argument is put by one party that, well, actually, these are just statements, admissions, concessions. They aren't efforts at negotiation. So very frequently, you'll sometimes see, again, it's more a tendency with litigants in person, they'll simply set out their stall and say, this is what I think about this case, and they'll post without prejudice at the top because they've seen lawyers do it. What about a case as in Bradford and Bingley versus Rashid, where in terms a debtor says something to the effect of, I do owe the debt, sorry, could I have a little bit more time? On the one hand, it seems to be a negotiation. On the other hand, it's a mere asking for a concession. Their lordship seems to take the view that if there had been some debate as to the quantum owed, for example, a concession that, look, I owe something, would qualify for the protection. But merely saying, all right, I owe you the money, can we do a deal of some sort? Can you, in terms of giving me a bit more time, didn't quite cross the line. Now, that is a very hard case, because one might take the view that there is genuine proffering or negotiation around the idea, or intended negotiation around the idea of time to pay. However, one thing I find interesting about this case is the majority of their lordships in the Bradford and Bingley case took into account the fact the document was not headed without prejudice. So the court had to divine an intention either to negotiate or not negotiate. And it's quite possible that in a borderline case like this, a proper label might have yielded a different result. That's one hard case. Another potentially hard case, at least in theory, is so-called mixed communications. So you have a meeting, or you have a chain of correspondence. Some of the documents are headed without prejudice. Some of the meeting has some effort towards negotiation that would otherwise attract prejudice without prejudice protection. But elsewhere in the meeting, there are statements, concessions, admissions that appear to be very useful to one party or another. Question: is the court likely to say, well, only some of this was without prejudice after all? Answer: no. The court is generally very reluctant to thin slice out, to extract or dissect, as it was put in the Unilever and Procter and Gamble case, to dissect communications, to take out the pith and marrow that represents that which is without prejudice and that which is not without prejudice. And the policy rationale for that is very easy. If, again, we want to have parties in a position where they feel they can unburden themselves and not worry about whether or not they're stepping in and out of without prejudice communications. So the general rule is that it will attach to the whole of a course of communication, be that an email chain, be that a discussion. The Shoe case before the Court of Appeal some years ago was an interesting application of that doctrine to a series of meetings and correspondence that was ancillary to that. The court rejected the submission that, as between us, one of the meetings was without prejudice and the other wasn't. The court will generally take a very wide and expansive view, even though every case is obviously fact-specific, and will generally err on the side of saying, if the purpose of this whole communication is aimed at negotiation, we will take the view that, in fact, all of it is protected. Another mistake that young practitioners are often in danger of making is in relation to waiver. Let's say you make a point in without prejudice communication, and then later you think, oh gosh, I'd like to tell the court about this very useful point that I've made earlier. Can I simply say to the court, it's all right, I no longer want to rely on without prejudice communication. I'm the one who wrote the document, and show the court all the useful things that you've been saying, which now help your case. Answer: no, the privilege is joint. So waiver of privilege is possible, but it's not enough for one party to simply to waive that privilege on their own. If one party does waive their privilege, the usual means by which one can do so in terms of making that, in terms of submitting those documents, the other party can agree that those documents are now to be put before the court. But what does that mean in practical terms? Well, practitioners should consider whether or not, in certain cases, they want to send out parallel letters and communications, one of which is open, one of which is without prejudice. But one thing I've sometimes suggested is that we simply repeat in later correspondence something in without prejudice correspondence that we do want to be before the court, some point that we made earlier, but we realize now is without prejudice, but we want to be able to cross-examine on or something to that effect. There's no harm in simply saying, furthermore, taking a block of text that you've submitted earlier. What are the exceptions to the privilege? if you want a one-stop shop for exceptions to the privilege, Unilever and Procter & Gamble sets out a big list of them. I'm not going to deal with all of those exceptions comprehensively, nor is the Unilever list comprehensive. There have been cases since which have updated those exceptions without prejudice doctrine. And by exceptions here, I mean cases where without prejudice would attach, but the court looks anyway. The court says, no, that is admissible as evidence. So we don't have a single compendium of exceptions. But I think there are two general rules that undergird most of those exceptions. And the first of those is bargains and their interpretation. So have we got a bargain? What sort of bargain have we got? If the whole point of without prejudice negotiations is to lead to some sort of settlement, some sort of concluded bargain, it makes sense that there should be some sort of backstop provision which says that the court can have a look in cases where we've reached that settlement. The second class of cases that, again, I think unites most of these exceptions that we're going to talk about is where the communication is doing something other than assisting in negotiation. It is assisting in negotiation, or it is part of a negotiation, but it takes on a different character. By very dint of existing, the communication is doing something. Now, that's a very airy-fairy way of trying to unite a number of examples that we'll look at in a moment. But there are plenty of exceptions. As I say, we're not going to deal with them all. There is, for example, a specific case in family cases, I believe, don't do family law, in which the without prejudice communication extends to cases where there's an attempt at reconciliation as between the spouses. Now, you'll be unsurprised, and I imagine most of you already know, that one of the most glaring exceptions without prejudice rule is when you have disagreement about evidence of a concluded bargain. So hopefully without prejudice negotiations have been proceeding very efficiently and smoothly. One party then says, I think we've done a deal, or you're trying to reduce one party says is heads of terms, and another party says is a completed deal. You're trying to reduce it to a concluded settlement. And a debate arises as to whether or not you crossed the line. Well, plainly in that case, the question of whether or not a deal has been done is a matter which the court needs to opine on, and it can't do so without the relevant documents. That first exception underlines a number of the other exceptions. So if one can look at the question of whether or not a deal has been done with reference to documents that are without prejudice, it must follow that those principles go a bit one step further and also allow you to look at the documents themselves as an interpretive aid. I can imagine that arising in cases where without prejudice discussions have led up to a certain point. The parties have then separately done a concluded bargain. And one party says, well, in order to understand this bargain, you need to go back to the without prejudice communications that we had before. Can they be used as interpretive aids? What it seems to me is, fortunately, the Supreme Court takes the same view that must be right. If, as we now know from the orthodox contractual interpretation rules, the background matrix of fact as between the parties is how is used to interpret what the words on the paper mean, then to shield the judge's eyes from that goes against that principle. Moreover, the principle of trying to allow parties to negotiate, to reach a concluded settlement, is already vindicated in this case. There's no benefit to giving the parties the benefit of secrecy in cases where they have already reached a concluded bargain and they don't suffer prejudice by the court having a look to see the way in which they were discussing contractual terms at an earlier stage. A third case, not one I've seen in practice, again is an extension of that same general rule. If you have an agreement, the court can look at that, makes sense. If you have an agreement and the court can look at the without prejudice discussions to understand its terms, makes sense. It must follow that where you've got cases where without prejudice correspondence involves misrepresentation, fraud, or undue influence, the court can look at that as well. Again, even I bring this under the heading of the bargain cases. You might have cases where there is a representation that amounts to an estoppel, which is made without prejudice correspondence. It doesn't necessarily meet the test for there being a compromise or an agreement, because there's no consideration, there's no meeting of the minds, but that representation might nevertheless give rise to reliance. And of course, it would be against the policy rationale of the courts to allow parties to make representations without prejudice correspondence, to allow another party to rely on them, and then to turn around and say, oh, well, you mustn't use that in evidence. This is a slightly more delicate case where you're trying to explain delay or acquiescence. It's not a case where I think you can easily divine a particular principled thread from the authorities. But suffice it to say, there is some scope for referring to negotiations and documents where you are trying to explain what would otherwise be delay or acquiescence. Sometimes it is enough, and sometimes it is permissible to look at cases where you refer to the existence of correspondence without dealing with its content. And an interesting case in Pearson Education in Prentice Hall, India, an applicant was criticised for not alluding to the existence of without prejudice correspondence when he'd made an application without notice footing. So he has a without notice application on foot. He has a duty of full and frank disclosure. And the judge says, well, you didn't even have to exhibit the correspondence, but you should have told me that it existed in order to give a fair picture of what was going on. And again, this could be a topic of its own. But one thing I would say is that judges are generally willing, the courts are generally willing at an inter-party stage early in the process, at an interim hearing, to look at the factor without prejudice communication in cases where it's not going to be relied upon at trial. If all you want to say is, we did respond to that letter, we did give them notice, etc., it may be that you can argue that one of these exceptions has been triggered. The hardest case, and I think the most academically interesting case of exceptions, is the case of unambiguous impropriety, which will cause the court to look behind the protection that without prejudice normally gives. And again, as you're probably tired of me saying at this point, the courts are reluctant to remove the protections associated with the without prejudice cloak. There's a very clear case where the court's willing to do that in the Halleck, Jersey case, which I've quoted from Phipson, where the without prejudice communication was used as a cloak for absolute and unambiguous blackmail. Where going so far as one party saying you're not going to blackmail me, the other side saying, but I have got to. Well, if you're blackmailing the other party and putting without prejudice at the top, don't expect the courts to protect you. But it has to be unambiguous impropriety. Again, it's a reluctance on the courts to make use of this doctrine. It's not as big or as expansive a doctrine, I think, as most practitioners might think on hearing those words the first time. There are more cases, it seems to me, from my survey of the cases, where it is raised unsuccessfully than successfully relied upon in order to defeat the protections of without prejudice rule. And a very interesting case, and I think a typical case, was considered in the Savings and Investment Bank and Finken case, because one might take the view that if there is a contradiction between something you've said in without prejudice correspondence and the case that you're running, say the case that you've pleaded in a statement of case, that might lead to unambiguous impropriety. Because it might be said you're setting yourself up, and in that case, potentially to perjure yourself. Saying one thing without prejudice communications, saying another thing, taking another position in your pleaded case, is a contradiction, which potentially even gives the possibility of perjury down the line. Is that contradiction enough for the court to say, unambiguous impropriety, you've lost your protection? The answer is it can't be mere inconsistency. And Lord Justice Ricks gives two justifications for that, which I think are quite compelling. The first is to say that, again, if we want parties to unburden themselves in negotiations, that will involve making admissions. That will involve them saying things and owning up to things, or at least making concessions they may not want to be used against them. So that's something we want to encourage. So the public policy rationale is quite obvious. But the second point he makes, I think, is equally compelling, which is to say that the whole point of this unambiguous impropriety exception is geared towards cases where it is the without prejudice cloak itself which is being misused. It's not merely that a party is not conducting themselves as they should. It's that they're using without prejudice in order to facilitate their nefarious ends. So in the case we looked at earlier, the Harwick, Jersey case, where someone was blackmailing their fellow disputant with threats, well, they're using without prejudice correspondence and the without prejudice shield in order to get away with something, in order to do something evil. If you're merely contradicting yourself and you're giving let's just say, a fuller picture of the truth in the without prejudice correspondence, well, actually, you're not misusing without prejudice correspondence at all, because you're using it to tell the truth. So you're not misusing the privilege, you're using the privilege quite properly. What you're doing in the main proceedings, in open correspondence, in your pleaded case, that might not be great, but you haven't been facilitated in using without prejudice correspondence in order to put forward that incorrect case. So Phipson goes so far as to say that you can generally distinguish between cases of perjury, where it's much harder to say that unambiguous propriety is underfoot, and cases of blackmail. I think the easiest way of looking at the rule is to don't look at the contradiction. You look at what is said in without prejudice correspondence. Is that communication itself facilitating the impropriety, or is this simply business a contradiction or something else within the litigation where we might criticize the behavior of the litigant, but it can't be said that what we have underfoot is some sort of fraud which is being facilitated by the without prejudice communications themselves. That, I think, brings us to precisely the half hour. Thank you so much for your attention, and thank you for those of you who followed me on other King's Young Professionals talks. As I say, I've had a good fun with this one. I've enjoyed putting it together. Thank you very much for your kind attention. Thank you.